Hello, my name is Andrew Kinney. I'm a Social Security disability attorney at Hoglund Law Offices, headquartered in Roseville, Minnesota. I handle about 500 or more hearings per year at this point. I started this work in 1992. In this video, I wanted to explain 4 things I want my clients to understand going into their Social Security hearings. Keep in mind that this information is general. If you need specific advice about your case, you are welcome to call our offices or get your own attorney, but it's important not to rely on this information. Also, it's important not to comment with personal information, questions about your particular situation. That's not private. Thank you. Here now are the 4 things I want my clients to know before their Social Security hearings. I'll list them first. Don't listen to what other people tell you. I would make myself an exception, I guess. Think of the main medical reasons you're unable to work. Understand the kinds of questions that you'll need to answer. And then finally, plan to give examples of how you're limited day to day. So I'll go through each one. First, I've had a lot of clients, certainly more recently, look online and they're told what to say at their hearings, how to say it. I think this is a grave error. Your medical issues are unique to you. The idea here is that you need to speak from the heart. You need to speak directly about what's wrong, not be reading things, not saying a certain thing a certain way. The idea here is that your medical records are usually making the decisions, but the judge is confirming your personal situation. Questions vary. I'll go through what kinds of questions they have, but you do not want to prepare answers. What I tell people, if this is helpful, what I tell my clients is that if you picture yourself on a first date and the person on the other side of the dinner table is in a restaurant reading off what they like to do and things about them, you wouldn't believe them for a second. So the key here is, even though you might wish to be prepared for your hearing, being prepared means to be aware and be present in the hearing, not trying to say the right thing, because hearings are not a test of what you know. Hearings are a test of your ability to answer questions directly, and the detail that you can offer is what makes you credible. So the second thing I want my clients to understand about the hearing is that there are main medical reasons you're unable to work. Someone might have 15 different medical problems, physical and mental, but there are some issues that limit you and your ability to work, and then others may not. For instance, high blood pressure it's unusual for that to cause symptoms. High cholesterol, again, highly unusual, if not ever, that it would be in itself limiting you and your ability to work. The main medical problems would be if you have a bad back, for example, if you have a bad shoulder and you can't reach forward or overhead, or if you have depression or anxiety. What I find with my clients is that there's usually a problem, physical or emotional or both, that's a lead issue, and other problems affect them, but mostly depression, for instance, or anxiety. At times it could be both. But in any event, plan to talk about the main reasons you're unable to work. Other problems are down the line for how important they might be. Third, going down this list, understand the kinds of questions you'll need to answer. These questions will be personal. They won't be general. These questions you'll be able to answer. If you have physical problems, you'll be able to talk about how long you can walk before you need to stop in minutes or blocks. You'll be able to answer how long you can stand before you might need to sit down, generally, a range of time. You'll understand how long you could sit upright in a chair with your feet on the ground before you might need to get up. Just have a sense, and your attorney, if you have one, should be able to go through the general idea here is with these questions. We would also, if someone has migraines, count them. How often do you have them during a week or a month? How long do they generally last? Again, it's a range of time, but these hearings are about sizing up how limited you are from here. And so with this for you, what's important is that you talk about how you're limited in your own words, in your own way. There are details here, details about your day-to-day functioning. For instance, leg swelling. Maybe it's one leg. Maybe it's certain things you're doing that cause the swelling. Maybe you need to elevate that one leg. Maybe you decided to do it on your own or with a doctor's help. You would want none of this, in my experience, laid out, written out, or prepared. Uh, the the idea is that you would want the judge to be able to understand from you how you're limited. So the kinds of questions that you would answer about, for instance, mental health would be, if you have anxiety, how do you have panic attacks? Do you get overwhelmed by anxiety? How often does it happen? What symptoms do you have before it happens? What situations does it seem to occur? And it may happen at times you don't predict. Well, we'll talk about that. If you have, again, a bad back, the questions might be, how much can you lift? Do you go grocery shopping? How do you handle getting in and out of a car? Do you drive even in general? So be prepared to help the judge understand your day-to-day functioning because it's natural to talk about it. In fact, you don't want to answer questions that someone else told you to answer. You don't want even your attorney telling you how to answer any of these questions. This is your life, and you know you better than anyone. That's what I tell my clients. And then finally, another thing I want my clients to know is I want them to be able to give examples, if asked, about what sorts of things you're unable to do anymore. If you love fishing and can't do that, if you love hunting, you can't do that, if you love bowling and can't do that, there are things such as hobbies, or there are things such as standing and doing dishes that you might struggle with. You might get help with. You might not do it at all. Before hearings, I talk to my clients about those sorts of things. Again, things you like doing, or even chores that you didn't like doing. You're able to mow the lawn. If you do you pace yourself? We help you understand how things have changed, because what I've noticed over the years is when you stop doing certain things, things you like to do or things you have to do, you might just get used to that other people are doing those things. So I get people to reflect a little bit on how things have changed since work ended. Uh, Examples like that, giving detail helps. If there's a certain way you need to get in and out of a car, the only person that can talk about it is you. And if there's a certain way you need to bend down to pick something up off the floor, again, this is unique to you. So the main idea through all this is that it does not help to write answers out, but it does help to understand the sorts of limitations you have and be able to have examples. Because hearings are a little odd, it's unusual, it's somewhat artificial, but you're laying out in a detailed way examples of what limits you. And in the end, the judge hears you out. The judge and the attorney talk to the job expert, and then you wait for the decision in the mail. There's no silver bullet, there's no magic formula, but the best course of action when you're talking with a judge, again, is to listen carefully to the questions, don't interrupt, and speak truthfully and directly to the judge about things that do or perhaps don't limit you. If this video was helpful, make sure to like us below. If you have comments, maybe about other videos you want me to try to do, I'd be happy to help you with them. And again, don't put personal questions on the comment area because they won't be personal anymore. Thank you very much. Take care.